When you enter a nursing home, there's a lot to think about. You will be given an admission contract that includes a lot of information related to the terms of your stay in the nursing home. Ideally, you will have legal counsel review the contract before you sign it. But there are things in your contract you should look out for and be aware of. One of them is a pre-dispute arbitration agreement that's commonly included in nursing home contracts. Pre-dispute arbitration agreements do not benefit residents, and you should not sign the pre-dispute arbitration agreement. You have the right to say no. But let's back up. You might be wondering, what is an arbitration agreement? Arbitration is a system of private justice, not a court proceeding. When parties agree to arbitrate their disputes, they give up the right to have those disputes decided in court. Instead, they agree to settle their disputes privately. An arbitrator acts as a private judge, and an arbitration agreement is an agreement between the disputing parties to refer current and future disputes to the arbitrator. The provisions in the nursing home agreement are called pre-dispute arbitration agreements because those agreements make you give up your right to go to court before the wrongdoing or harm even occurs. You never have the chance to decide if going to court is the right option for you. Pre-dispute arbitration agreements are a few sentences embedded or hidden inside of a bigger contract or maybe on a separate form. In nursing home admissions contracts, these sentences take away your right to hold your nursing home accountable in court if you are harmed, and instead require you to have your dispute heard by an arbitrator. Arbitration is used by nursing homes to hide negligence, elder abuse, and other wrongdoings. So when would this actually matter? What counts as a dispute? A dispute is any event in which you are harmed in any way. So once you've signed an arbitration agreement, if you've been neglected or abused, you cannot take the nursing home to court. You cannot bring a lawsuit. Instead, you might end up in arbitration. You don't get a judge and a jury. Instead, you have a private arbitrator who decides the outcome. The decisions are always final, barring extraordinary circumstances. So once the arbitrator finds for the nursing home, which they almost always do, you cannot appeal the decision. And the decisions are confidential, which means no one else gets to find out what the facility did wrong. Arbitration doesn't have to follow the rules of evidence, and arbitration can be far more expensive for a resident than a lawsuit in court. So there are no advantages to any of this, only disadvantages. Nursing home residents do not have to sign these agreements and actually have rights that protect you when you encounter them. First of all, the nursing home has to tell you that the arbitration agreement is in your contract, and they have to tell you that you don't have to sign it. In addition, they cannot deny you admission or discharge you because you decide not to sign an arbitration agreement. And if you do sign one, you must be allowed to rescind it or undo it within 30 days of signing. So if you're listening to this and you just moved into a nursing home and didn't realize you agreed to pre-dispute arbitration, ask to see your contract and tell them you want to rescind the arbitration agreement. If you're moving into a nursing home and there's an arbitration agreement in your contract, cross it out. Put your initials and date next to it. If it's on a separate form, do not sign it and remove it from the packet. You have the right to say no to pre-dispute arbitration. Don't let the nursing home pressure you. If you are concerned, reach out to a lawyer or legal services in your area.